If you hold a green card and your husband, wife, or child is still waiting for the chance to join you in America, I need you to pause everything you are doing right now and listen carefully, because what just appeared in the April 2026 Visa Bulletin represents one of the most important developments for permanent residents and their loved ones in quite some time. There is a filing window available right now, a genuine act on it immediately kind of opportunity. And the crucial detail you must grasp is that this window could close at any time. So over the next few minutes, we are going to break down precisely what shifted, precisely who is impacted, what actions you should take, and the serious caution that accompanies all of it. This is US Updates Hub, and my purpose is to help you decode what is truly going on so your family can seize this moment. Let us dive right in. As of April 10th, 2026, the U.S. Department of State released the April 2026 Visa Bulletin, and USCIS, which stands for U.S. Citizenship and Immigration Services, has formally verified that both family-sponsored and employment-based filers may utilize what is known as the Dates for Filing chart this month. Now, if that terminology sounds foreign to you, do not worry. We are going to lay it all out simply. But for those who have been navigating this journey for months or years, you already recognize what that verification signals. It signals that a pathway has been unlocked, and the marquee development inside that bulletin, the one that carries the greatest weight for green card holders, is what occurred within a category known as F2A. Let me break down what F2A means, because this is the foundation of everything we are discussing today. The F2A preference category encompasses spouses and unmarried sons or daughters below the age of 21 of lawful permanent residents. Put differently, the closest family members of individuals who possess green cards but who have not yet obtained U.S. citizenship. These are the husbands, wives, sons, and daughters of millions of permanent residents who live and earn a living throughout this nation. Typically, individuals in this category encounter a waiting list. They wait sometimes for months, sometimes for many years. There is a queue, and they must remain in it because Congress sets yearly limits on the number of green cards that can be granted in each preference category. And when the number of applicants surpasses availability, cutoff dates are established and people wait for their place. That is the standard reality for F2A families in the queue. But here's what just shifted. The April 2026 Visa Bulletin displays the F2A category as current on the Dates for Filing chart, and this has not occurred since 2022. When a category appears as current, it indicates there is no waiting list cutoff at that point. It indicates that qualified applicants can submit their adjustment of status application, which is the form I-485 right now, without needing a particular priority date to become available for F2A filers. That is a remarkable development. A current label means that no matter what your priority date is, you may be able to submit the adjustment of status application now, obtain work authorization, and secure your position in line while waiting for the final action date chart to progress. Let us be extremely specific about how the Visa Bulletin operates, because there is a distinction here that is critically important and that a great many people misunderstand. The Visa Bulletin releases two separate charts every month. The first is known as the Final Action Dates chart. This is Chart A, and it indicates when a green card can actually be granted and physically delivered. The second is known as the Dates for Filing chart, Chart B, and it indicates when you can turn in your documents, your I-485 application, even though your green card has not yet been granted. The State Department's April 2026 Visa Bulletin details when green card applicants can proceed using these two charts. Final action dates, which establish when a green card can be granted, and dates for filing, which reveal when applicants may turn in their documents. USCIS must independently authorize which chart filers should reference each month. And for April 2026, USCIS has verified that applicants in every family-sponsored preference category should reference the dates for filing chart for both family-sponsored and employment-based preference categories. USCIS has instructed applicants to reference the dates for filing chart in the Department of State Visa Bulletin for April 2026. So, why does submitting early under Chart B carry so much significance, even when the green card has not yet been granted? Because submitting your I-485 activates advantages that can reshape your family's everyday existence while you wait. A current label activates the ability to submit Form I-485 right now, become qualified for a green card interview once a visa number opens up, and gain access to temporary advantages in the interim. Among those temporary advantages is the ability to request an employment authorization document, widely referred to as an EAD, which permits the applicant to work lawfully in the United States. It also permits them to request advance parole, which is essentially prior approval to travel abroad and re-enter the U.S. without giving up the pending green card application. These are not minor details. The ability to work lawfully, to travel, to establish a life while the final decision makes its way through the system. For families who have endured separation or who have a spouse trapped in legal uncertainty without work permission, this is transformational, and it becomes available the instant that I-485 is submitted. Now, I want to address the caution because this is precisely where we must take a step back and speak honestly with one another, because the opportunity is genuine, but so is the danger of delaying too long. The April 2026 Visa Bulletin contains a direct warning from the Department of State. Dates across numerous immigrant visa categories were pushed forward partly because visa approval rates have declined for specific countries under current administration measures. And the bulletin explicitly notes that retrogression, meaning dates shifting backward, may become necessary later in fiscal year 2026 as demand trends evolve. Let that register for a moment. The State Department itself, in its official bulletin, is cautioning that these pushed forward dates may not endure. Retrogression means dates reverse direction. It means the window shuts, and if you have not submitted your application before that occurs, you forfeit access to all of these advantages: the work permission, the advance parole, the ability to secure your position, and you return to the waiting period. How long would that wait last? Nobody can predict. The previous time F2A appeared as current was briefly in late 2022. The F2A category held current status briefly in late 2022, then retrogressed for more than 3 years. Families who did not act during that window waited over 3 years for another opportunity, and that opportunity is now today. So let us discuss who precisely this pertains to, because I want to ensure you are meeting the right criteria before anyone rushes to submit documents. To take advantage of this F2A filing window, the sponsoring family member, the individual who already resides in the United States, must be a lawful permanent resident, meaning they possess a green card, not U.S. citizenship. This is a vital distinction. If your sponsoring spouse has naturalized and obtained U.S. citizenship, your category may have shifted. Spouses of U.S. citizens qualify as immediate relatives with no visa waiting list whatsoever, which is actually more favorable news for those situations. So, if your sponsor has already obtained citizenship, you may actually occupy an even stronger position, and you should consult with a lawyer about how that influences your petition. But for those whose sponsoring family member holds a green card and has not yet become a citizen, the F2A window represents the opportunity before you. Additionally, there must be an approved Form I-130, which is the petition for an alien relative that places the beneficiary in the F2A classification. If that petition already has approval, the applicant may be prepared to submit the I-485. Now, if it has not been submitted or remains under review, that is a discussion to initiate with a lawyer right away about how to accelerate or move forward. One more essential detail here. If a child within the F2A category is nearing their 21st birthday, timing becomes critically important in a very particular and pressing manner. If a child reaches 21, they graduate out of F2A and transfer to the F2B category, which carries a significantly longer waiting period. The Child Status Protection Act may offer some protection, but submitting the I-485 before the birthday is essential. If you have a child in this predicament who is approaching that age threshold, please do not postpone action. Reach out to an immigration lawyer at the earliest opportunity. Now, let us go through what the procedure actually entails for those who qualify and are prepared to submit. The central application is Form I-485, which is the application to register permanent residence or adjust status. This is the primary green card application for individuals who are already present within the United States. Together with the I-485, applicants generally submit Form I-765 to request employment authorization and Form I-131 to request advance parole for travel. These forms are customarily submitted together as a single package. You will additionally need a completed Form I-864, which is the Affidavit of Support, a financial document from the sponsoring green card holder demonstrating they can financially sustain the applicant, normally accompanied by recent tax returns, pay stubs, and bank statements. You will need to arrange a medical examination with a USCIS designated civil surgeon who will complete Form I-693. You will additionally need 2 passport-style photographs meeting USCIS specifications, copies of your approved I-130 petition, identity documents, and immigration history documentation. The USCIS website at uscis.gov contains the complete and current submission requirements for Form I-485, and I consistently encourage people to confirm those requirements directly from the source before putting together a package, since requirements can be revised. One thing I want to make absolutely clear: submitting quickly and submitting accurately are not identical things. In immigration, an incomplete or improperly prepared application can trigger a request for evidence, what USCIS refers to as an RFE, which can slow the entire process considerably. In certain instances, mistakes or absent documents can lead to a denial. A seasoned immigration lawyer can examine your particular immigration history for any concerns, coordinate your medical exam scheduling with your submission, confirm your admissibility, and advocate for you if USCIS does issue a request for evidence. This is a juncture where professional counsel is truly worth seeking, particularly given the possibility for retrogression to shut the window before you can amend and resubmit. Let us also recognize something broader that is unfolding in the immigration environment right now, because context is essential for understanding why this bulletin appears the way it does. The April 2026 Visa Bulletin mentions that immigrant visa approval rates for aliens from particular countries have declined as a result of various administration actions undertaken to safeguard national security and public safety. As a result, to distribute visas in compliance with the law to prospective immigrants from other nations, dates for filing and final action dates have been pushed forward across multiple immigrant visa categories, U.S. Department of State. In straightforward terms, particular countries are seeing fewer visas utilized due to policy-driven slowdowns in consular operations, and that releases numbers that are then reallocated to push dates forward for other categories and nations. That is one explanation for why F2A returned to current standing and why other family-based categories also experienced advancement this month. But it also reveals something significant. The forces behind this window are not conventional demand-based forces. They are policy-driven, and policy can shift. The Department of State has been forthright about that within the bulletin itself. Beyond F2A, there are additional developments in the April 2026 bulletin worth highlighting for green card holders whose relatives fall under different categories. Family-based categories experienced broad forward advancement this month, with the most prominent gains appearing in F1, which encompasses adult sons and daughters of U.S. citizens, and progressed by roughly 6 months across most nations. F2B and F3 categories also shifted steadily forward, while F4 registered modest advancement. On the employment-based side, EB2 India progressed 6 weeks, and EB3 China advanced 2 months. EB1 worldwide stays current, but EB1 India and China remain fixed at April 2023. If you belong to an employment-based category, review the official USCIS adjustment of status filing charts page directly to verify your qualification for the dates for filing chart this month and monitor your priority date attentively. There is also a development on the tax compliance front that every green card holder must recognize because 2026 has introduced heightened examination at the junction of immigration status and tax returns. USCIS released a policy memorandum in September 2025 that expands how officers evaluate good moral character for naturalization and tax compliance, now holds greater significance in citizenship determinations. In addition, a data exchange agreement permits verification of certain address and filing history details between the IRS and immigration enforcement authorities in restricted circumstances. What this means in practice is that if you hold a green card with overseas income, foreign bank accounts, or any inconsistencies in your tax filing record, now is the moment to ensure your records are precise and fully compliant. April 15th, 2026 is the federal tax submission deadline for the 2025 tax year. And for a green card holder, this deadline carries implications beyond tax penalties. It can influence future immigration proceedings, including naturalization, and in certain scenarios, questions about relinquishment of lawful permanent resident status. Tax obligations and immigration standing are increasingly intertwined, and this is a domain where both a competent tax professional and an immigration lawyer can provide tremendous value. Let me pull everything together with some tangible real-world actions you can pursue right now. First, if you hold a green card with a spouse or unmarried child below 21 who has an approved I-130 petition and resides within the United States, visit USCIS.gov today and examine the official adjustment of status filing charts for April 2026. Verify that USCIS has approved the use of the dates for filing chart for your classification. If your beneficiary resides outside the United States, reach out to a competent immigration lawyer about whether consular processing alternatives exist for you and what this bulletin signifies for your situation specifically. Second, if you believe you qualify under F2A, begin collecting your documents now. Do not hold off until the final day of the month. Arrange a medical examination with a USCIS civil surgeon at the earliest opportunity because there can be scheduling delays. Assemble your financial sponsor documents, your identification documents, your approved petition, and your immigration history records. Third, think about consulting with a qualified immigration lawyer before submitting. This does not need to be an extended engagement. Many lawyers provide consultation sessions specifically designed to assess your filing preparedness. Given the threat of retrogression, acting swiftly but accurately is the objective. Fourth, regardless of whether this specific window pertains to your family, develop the practice of reviewing the USCIS website at uscis.gov and the State Department's Visa Bulletin at travel.state.gov each month. These are the official definitive sources. No media outlet, no social media update, no video, including this one, should serve as the foundation for your filing decision. Always confirm with official sources and your personal legal advisor. Before I conclude, I want to present a straightforward and heartfelt disclaimer. Immigration policy in the United States is subject to revision, sometimes swiftly and with very minimal advance warning. The details presented in this video are accurate as of April 10, 2026, and are drawn from official guidance from USCIS and the U.S. Department of State, as well as coverage from trustworthy legal and news organizations. However, nothing in this video amounts to legal advice. Every immigration case is distinct, and the appropriate course of action for your family hinges on your unique history, circumstances, and the most up-to-date available guidance. Please confirm all details with official government sources and speak with a qualified immigration lawyer for advice specific to your personal situation. Policy modifications can and do happen, and what holds true today may shift next month. That said, I want to conclude with this thought. For families who have been waiting and yearning and tallying the months, this April 2026 bulletin is truly meaningful. The F2A current label is uncommon. It surfaced briefly in 2022, and then it vanished for over 3 years. It has returned again now. Whether it persists for another month or whether retrogression arrives before the next bulletin appears, no one can declare with absolute certainty. What you can command is whether you respond to it. If you have been following this channel for any length of time, you understand we are always direct with you. The opportunity is genuine. The caution is genuine. Both of those realities coexist at the same moment. If this video proved valuable to you or to someone in your household, please take a second to like it and pass it along. You would be truly amazed how many individuals are in exactly this predicament and do not yet realize this window exists. Passing along this video could alter someone's trajectory. And I say that with complete sincerity. Subscribe to US Updates Hub so you do not miss our monthly Visa Bulletin analyses, our coverage on USCIS policy developments, and our accessible language reporting on the changes that impact you and your loved ones most. Review the description of this video for links to the official USCIS adjustment of status filing charts, the April 2026 State Department Visa Bulletin, and resources for locating a qualified immigration lawyer in your vicinity. We are here to support you. We will continue monitoring, continue covering, and continue delivering you the knowledge you need to navigate this system with assurance. Stay educated, stay ready, and look out for one another. I will see you in the next one.